8FH. Counsel, you want to state your appearances, please?
Jeremiah Buffalo Word on behalf of the people.
Your Honor, Mike Vogler representing Sean Hoffman.
All right, and this is a docket call, but also the defense has filed a motion to quash count 2, the R&O. I reviewed the transcript, the motion, the authority cited, and just this morning, the memo filed by the people. Mr. Vogler, go ahead with any argument.
Your Honor, not much to add to what I've already written to the court, but it seems to me that there are 3 cases, all unpublished, that were provided to the court, all of them identical in terms of this case, with the exception of the resisting and obstructing charge here versus the ones in those 3 cases. In those 3 cases, all 3 resisting and obstructing convictions were upheld, along with the convictions for fleeing and elude. And I submit the reason they were upheld, and I think the court in each and every one of those cases cited the fact that after the fleeing and eluding offense was completed, the defendant in some way or another disobeyed a direct verbal command from the officer to do something, either stop, get out of your car, or what have you. In this case, once that fleeing, eluding episode was done, in this case, as alleged, the defendant got out of the car, got into the house, came back out of the house. There was no verbal command in between from the time he left the car, or even when he was in the car and got out and got in the house and came back, that he disobeyed.
So the prosecutor's argument seems to be both below and here that the light signal itself was a command of some kind, what was a lawful command. And then by fleeing on foot, there's a failure to obey that lawful command. Is that right or wrong, or what and why?
I think it's wrong. I think that the command, the 3 cases I provided to the court indicated a verbal command was what was necessary. And to say it's otherwise would make every fleeing and elude would be in a resisting and obstructing. I don't think that was the intent. The courts, from what I can tell, don't believe that that was the intent, that the disobeying, the obstruction part of it, the disobeying has to be to a verbal command, a lawful verbal command.
Right, thank you. Mr. Porto, are you arguing this thing?
I am, Your Honor.
Okay, go ahead.
Your Honor, defense's reading of the statute here would require that there needs to be a verbal command in every single R&O. That would prevent people who can't hear from being convicted of R&O, and it would prevent a lot of situations for R&O. But it's not just R&O, Your Honor. I mean, even in the title, it says assaulting, battering, resisting, obstructing, opposing. And then within the statute, it even says endangering. Now, there is a part of the statute, and I believe it's sub 7 A, where it says that obstruct includes. The word includes was chosen very specifically, Your Honor, meaning, yes, it can be that. It doesn't say includes failure to obey a lawful command and excludes everything else. It just says that it includes. Your Honor, I do think that we can have our cake and eat it here too. I think inherent in almost every single fleeing and eluding there is an R&O. That aside, Your Honor, the moment Mr. Hoffman decided to haul from that car, that was a new crime. And I do believe that the element of knowing that he's being chased, he admitted, I'm afraid of the cops. And I don't think that it requires a verbal command. I think that the flashing lights, knowing he was being pulled over, is adequate enough to know that he was hindering, that he was resisting, and even if we're not going to say he was obstructing, he certainly did endanger those officers that day. And finally, Your Honor, if we were to interpret defense's reading of this statute it's an invitation to run. The moment I get pulled over to the side of the road, it is time to beat the pavement, because if I can't hear that cop tell me to stop, then there's no extra crime. Thank you.
Any rebuttal argument, Mr. Booker?
No, Your Honor, I'll stand on what I've already said.
All right, on a motion to quash, typically that's viewed for an abuse of discretion. However, a court abuses its discretion when a decision makes an error of law. So determining the scope of a criminal statute is a matter of statutory interpretation, which is a question of law. Therefore, my review of these questions would be de novo, requiring no deference to the district court. In this case, I'm going to grant the motion to quash count 2, resisting and obstructing. Here, there's a very specific statute about fleeing and eluding from the police. It's not an invitation to run all the time. It's a felony. So people don't stop their car when they're in. The statute shows that the legislature knows how to write such a statute, that if they fail to bring the vehicle to a stop when they're given a signal by all sorts of very specifically described methods, then that's the crime of fleeing and eluding. You know, I recall in the past, there were a series of cases trying to sort out, you know, is running from the police on foot an R&O? And is it an R&O at all? And the cases were decided that, yes, running from the police on foot can constitute an R&O, resisting or obstructing police, when it is failing to comply with a lawful command. And here, the visible signal to stop the vehicle is not the same as a lawful command. Command does imply some verbal command that is given. And, you know, all it takes is then if an officer says, hey, stop, and then they keep running, well, that's resisting and obstructing a lawful command. And whether they heard it or not would be a fact question for a jury in certain situations. But here, there were no facts that really called into question. There was no command given to stop once he's outside the vehicle. Therefore, I think there's a necessary element that would be missing. So the defense motion to quash count 2 is granted. And Mr. Vogler is the prevailing party. Can you submit an order to that?
I will, Your Honor.
So for purposes of docket call, then, where are we at here?
Well, unfortunately, the communication with my client is very troubling, at least from my perspective. The last time, I think we were in court, Mr. Hoffman, I thought, indicated that he wanted to go to trial. I think that's still what he wants to do. I don't know for 100%, but he has a way of being able to communicate with me. He can pick up the phone in the jail and tell them, leave a message. I will certainly come over as fast as I can to see him.
Okay. All right. So, Mr. Hoffman, your lawyer's telling me, are you awake there with us?
Yeah.
Okay. Your lawyer's telling me that you don't seem super interested in communicating with him about the case, but that he thinks that you'd like it set for trial. Do you want me to set this for a jury trial for you, Mr. Hoffman?
Yes.
Okay.
If you have an ordinary to flee and elude, you have to be pulled over, and I was never pulled over. It's even states it in the police report that I was in the house for 22 seconds. If I was in the house for 22 seconds, that means that there was no pull over.
Okay, well, you can sort that out. And we're here for a docket call. And Mr. Wirgo, while I was in chambers with Mr. Gilbert, Mr. McClendon, Mr. Gilbert did give me the plea agreement. Of rights. Would you please raise your right hand for me? Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes. Put your hand down. Are you Michaela Hayes? Are you Michaela Ann Hayes? Ms. Hayes, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that we have. I want you to listen carefully. If you have a question, ask me. If you need to talk to Mr. Gilbert, you just say so. Mr. Wirgo, are you, do you have an amended information?
Your Honor, I'm not handling the criminal matter.
Oh, I'm sorry. Sorry, Mr.
I
McClellan.
am, Your Honor. We do not have an amended information right now.
Okay. Will you file one forthwith then?
Yes.
And count 7. All right, Ms. Hayes, I'm sorry. If it to advise you the maximum penalty that you could face on the charge of count 5, maintaining a drug house is a high court misdemeanor punishable by 2 years and or a $25,000 fine. Count 7, which will be added later, is a charge of possession of methamphetamine that's punishable by a maximum of 10 years in prison and or a $15,000 fine. Do you understand the maximum penalty?
Yes.
Are you on probation or parole anywhere?
No.
Were you on bond for any other case at the time of this incident?
No.
Did you read and understand the rights on the advice of rights form?
Yes.
You signed that? You understand if you plead guilty, you give up those rights and won't have a trial?
Yes.
Is that what you wish to do? I accept your plea. You give up any claim that it was caused by threats or promises outside the plea agreement. Do you understand that?
Yes.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. The types of issues you could raise would be very limited. Do you understand that?
Yes.
The plea agreement provides in exchange for your plea to those charges that I outlined. The prosecutor will dismiss the remaining charges. And there's a sentence agreement for a 1-year delay of sentence with no jail. And then if you successfully complete probationary terms during that delay, then the possession of methamphetamine charge would be dismissed, and the maintaining charge would be the only thing on your record then. Do you understand that?
Yes.
Mr. Glover, is that a full, clear, and accurate statement of the terms of the agreement?
It is.
Yes, Your Honor.
Ms. Hayes, that sentencing agreement is not binding on me. If I didn't want to follow it, I wouldn't have to. But if I didn't follow it, you'd be allowed to withdraw your plea unless you got in some kind of trouble between now and the sentencing. Do you understand that?
Yes.
If you got in trouble between now and sentencing, either by not appearing or violating bond or committing a new crime, you'd lose the right to withdraw the plea, even if I didn't go along with that. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you, did you within that dwelling possess the controlled substance methamphetamine?
Yes.
Did you have any lawful authority to possess it?
No.
Did you know what it was you were possessing?
Yes.
And did you possess that substance in that dwelling on more than one occasion?
Yes.
Mr. Gilbert, you satisfied with that factual basis?
I am, thank you.
Mr. McClellan?
Yes, Your Honor.
Mr. Gilbert, you aware of any other promises, threats, or inducements?
I am not.
Mr. McClellan?
No, Your Honor.
Mr. Gilbert, in your judgment, has the court fully complied with the requirements of 6.302?
I believe the court has, thank you.
Mr. McClellan?
Yes.
All right, Ms. Hayes, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for December 1st, 10:50 in the morning. You'll have to cooperate with a pre-sentence report being prepared. So I want you to talk to Agent Lesky before you leave. Mr. McClellan, any objection to continuation of bond?
No, Your Honor.
Bond to be continued. See you then.
Thank you, Your Honor.
Just then to people to Joshua Pritchett.
Mr. Pritchett, ready to go, Your Honor.
Five 93370FH, and what's our status here?
Your Honor, the prosecutor and I met last week regarding this case, and I've updated Mr. Pritchett on that. We are working on a resolution. I'm pretty confident that that's going to happen.
This is our first docket call. We're just asking for some more time.
All right, and the top charge is sort of a complicated charge, so I think there's good cause to do that. And continue it to December 1st at 11 a.m.
Your Honor, is there just one date at the beginning? Because I thought earlier I heard you say December 5th.
It's December 1st.
Okay.
If I said 5th, that'd be a mistake.
Okay.
Which would not be the first time.
Yeah, you said that.
Oh, it's the 1st.
Okay, thank you.
We know he won't show up on the wrong date.
Yeah, well, I'll make sure. I'll make sure he's informed.
It's December 5th and December 1st and January 5th.
Gotcha. Okay, thank you.
So this will be December 1st at 11 a.m. All right, anything further from the people?
No, Your Honor, thank you.
You're all set, sir.
Thank you.
And then that brings us to people with Tiffany Gagnon, 5-93271. She was at residential treatment back in September, but now it's been hit.
Your Honor, that's where she was. I thought, and I've been trying to track her down. I thought she was at the Sunrise Center. I called and it appears she's no longer there. And I did try to contact her via telephone. My numbers aren't working. However, she has always religiously been in contact with me. So I'm not too sure what's going on. I did make contact with the Sheriff's Department. They said they would assist me in trying to figure out if we can find where she's at, or if she's at a different treatment facility. I was really hoping she was going to Zoom in today.
Yeah. All right, Mr. McLennan, what's your thoughts?
Your Honor, she has appeared for everything previously and been reliable. Be fine with just show pause and setting it for further docket.
Okay, so let's put it on for docket call December 1st. 11:10 a.m. in person. And we'll do a show cause for her non-appearance in today's date. And also continue the bond violation for the older missed tests to the same date and time.
Thank you, Your Honor.
All right. I think that concludes our morning docket.